one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Now I invite the Honourable Chief Justice of Kenya, the President of the Supreme Court of Kenya, Martha Koome, to deliver their response.
Thank you for giving me this opportunity to share a few thoughts on the topic, backsliding of the rule of law. I am honored, greatly honored, to join you, although virtually, for this important lecture organized under the Global South Network Judges guest lecture series. I want to begin by thanking Dr. Nauman Reayat for the invitation to offer brief reflections in response to the timely theme, Backsliding of the Rule of Law. I also want to extend very warm greetings to Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland, and commend his great leadership in advancing principled judicial discourse at a moment when such conversations are both necessary and urgent. The discussion of backsliding of the rule of law is not abstract, because across jurisdictions we observe pressures on judicial independence. We observe contestation of electoral outcomes. We observe erosion of public trust in institutions. We observe shrinking of civic space and heightened political polarization. In certain contexts, colleagues, courts are criticized for what is seen as overreach, and in others for what is viewed as restraint. Yet, in each of these situations, the rule of law depends upon a judiciary that is independent, a judiciary that is impartial and constitutionally anchored. In Kenya, the 2010 Constitution marked a profound and transformative institutional reset. It is structured or restructured the judiciary to enhance independence, accountability, and public confidence. The Supreme Court of Kenya stands at the apex of this architecture. The court, which is composed of 7 judges, exercises exclusive original jurisdiction in presidential election disputes, as well as appellate jurisdiction in constitutional and other significant matters of public interest. The decisions of the Supreme Court are final and binding, and it is entrusted with the solemn responsibility of interpreting and safeguarding the Constitution. Our court structure in Kenya reflects an intentional design to entrench separation of powers while fostering transparency and reasoned decision making. Hearings are conducted publicly, judgments are delivered with detailed reasoning, and dissenting opinions are welcome, acknowledging that constitutional dialogue often evolves over time. The openness is critical to sustaining public legitimacy, especially in politically sensitive cases. Kenya's Supreme Court has adjudicated matters that may offer insights to superior courts worldwide. Its presidential election jurisprudence, for instance, has demonstrated that courts can scrutinize electoral processes rigorously while maintaining institutional calm. In nullifying a presidential election in 2017, the Supreme Court affirmed that fidelity to constitutional procedure is not secondary to political expediency. That decision underscored a simple principle that the rule of law requires that even the highest office be subjected to constitutional scrutiny. Beyond electoral disputes, the court has developed transformative jurisprudence in areas such as public participation, devolution of power, environmental governance, and socio-economic rights. It has emphasized that constitutionalism is not static. Constitutionalism is a living project that demands accountability, inclusivity, and protection of the marginalized communities and vulnerable groups. Importantly, judicial courage must be matched with judicial discipline. Dear colleagues, guarding against the backsliding of the rule of law requires not only bold decisions, but institutional integrity, transparency, and fidelity to the law. Courts must avoid politicization and isolation. Courts must remain independent, yet responsive, and principled, yet attentive to the lived realities of the people they serve. In Kenya, we are also pursuing reforms under the social transformation through access to justice, following our blueprint to ensure that the rule of law is experienced by citizens and that the law and the justice services are accessible and meaningful. When the rule of law is only anchored in court decisions and not grounded in everyday lives of citizens, it becomes vulnerable. By strengthening alternative dispute resolution mechanisms, enhancing digital access, and promoting people-centered justice, we seek to reinforce the social foundation upon which the rule of law and judicial authority ultimately rests. Finally, on judicial cooperation among superior courts, at a time of global uncertainty, transnational judicial dialogue is indispensable. Judiciaries across the world face similar challenges in regard to climate change matters, digital governance, electoral integrity, and human rights protection. Therefore, these structured exchanges such as this and other judicial colloquia, clerkship collaborations, and shared research platforms can deepen collaborative learning. Such collaboration does not dilute sovereignty of each jurisdiction. It actually enriches jurisprudence. It also affirms that while our constitutions are national, the values underpinning the rule of law are universal. As I conclude, I must emphasize that backsliding of the rule of law is not inevitable. It can be resisted through principled adjudication, institutional vigilance, and solidarity among courts committed to constitutional governance. Once again, I want to sincerely thank Global South Network for convening this important dialogue and for the gracious invitation. My apologies, I could not make it physically due to exigencies of duty. But may our collective reflection strengthen our shared resolve to uphold the rule of law firmly, faithfully, and without fear or favor. Thank you, and may God bless you.
Thank you very much, the Honourable Chief Justice of Kenya, for delivering our response.